Holdings versus Factory Mutual Insurance Company. We'll hear first from Mr. Guthrie. Oops.
Thank you, Your Honor, and may it please the court. Andrew Guthrie for the appellant, Baylor, Scott & White. I've reserved 5 minutes of my time for rebuttal. This is an insurance coverage case arising out of the COVID-19 pandemic. Now, I know this is not the first case to bring this kind of dispute to the court, and so I appreciate the opportunity to present oral argument today, because I just don't think this case is like the others that have come before it. And so in my time today, I want to focus on the two big differences in this case that we think should lead to a different result here. First, on the detailed allegations of physical loss or damage that Baylor alleged in its complaint. Second, on the unique language of the all risks insurance policy that Factory Mutual issued here to cover communicable diseases, among other things. Because this case comes up on a motion to dismiss under Rule 12b-6, our task here was relatively straightforward. We simply had to make plausible allegations that COVID caused physical loss or damage to our property under the terms of our insurance policy. And we did so because, more than any other complaint this court has seen, we were able to marshal the evolving scientific literature and explain how COVID tangibly altered our property, thus triggering coverage even under this court's existing eerie guesses. But in addition to those detailed allegations, we've got a different insurance policy. We have an additional coverage for communicable diseases that, based on its text and in the structure of this policy, demonstrates that communicable diseases can cause physical loss or damage, again, at least for purposes of this policy. So for either of those reasons, this court should reverse and remand for discovery and fact-finding on the merits of those issues.
Communicable diseases cause cause these losses.
Yeah, absolutely.
According to your pleading, explain this to us.
Absolutely, Your Honor. So to reset the standard a bit, what this court has said is that physical loss or damage means a tangible alteration or deprivation of property. And that goes back to Terry Black's. And what the court said in Terry Black's, right, when we were breaking down those terms, it talked about what is physical. Physical is pertaining to real or material or natural things. And then when it talks about an alteration is just when a property goes from an initial satisfactory state and is being changed by an external event into an unsatisfactory state. So I want to get to where our...
The physical,
Absolutely.
You used to spray everything down because you thought you could get COVID from things touching things, and then we learned it was airborne, and so...
That's right.
So you need to be close to someone who's sneezing or something.
But what we have learned since the outset of the pandemic, and this was the scientific studies that we gathered in our first amended complaint, is what we know is that the spikes on the outside of the COVID cells, they can chemically and electrostatically bond to the surfaces of the property at our hospitals. And when those physical bonds happen, there is a physical alteration of the property where the property becomes measurably rougher. It becomes more hydrophobic. It's more likely to repel water.
So all our cases denying property damage for COVID need to be rethought?
I'm not sure I'd say they need to be rethought.
Maybe,
we're talking about the specifics.
No, I'm sorry. I mean, we're going to get, so if we agreed with you here, we're going to get petitions in all those other cases. And it's probably untimely, but we'll get the petitions anyway. And they'll say, rethink it. It caused property damage. We know that now. I think I was on one of those panels.
I understand that, Your Honor. I think all I would say is that when the facts on the ground changed, COVID was unique for all of us. The things we knew in March 2020 are very different than the things that we know now. And so when the science evolves, I think the court, to its credit, at the outset of these cases, was evaluating the allegations that it had before it. So Terry Black's is a perfect example. Terry Black's was a case where the plaintiff was alleging that it had business interruption losses from the government closures. So what did the court do in Terry Black's? It evaluated those allegations and said, no, this has to be a physical alteration. The government closure doesn't cause a physical alteration, but that's the allegation that they had there. As the science has developed, we are now able to say, and remember, we're at a motion to dismiss stage, right? So these facts have to be taken as true. We've got the scientific studies in our pleading that say look, when we look at what COVID does and how it interacts with the property, it does tangibly alter the property.
What does that mean to be more hydrophobic or whatever?
More likely to repel water. It's a term that I learned in this case.
So you're saying the counters at the hospital repel water? How does that affect it? I mean, how does anyone notice that? Or I don't understand.
Well, so again, we're going off the science that we have in our complaint, and the science.
Help a lay person.
Certainly.
Not a STEM major, understand what you're saying. I don't. So.
Well, can I go about it this way, Judge Elrod? The fact that it's not a visible change is not ultimately relevant to whether we have a tangible alteration for.
Does it cost any money? Does it matter if the thing is more hydrophobic? Does it cause any damage? Is it the property less valuable or less suitable for its purposes?
So two answers to that, Judge Elrod. First, it does. So because of these physical alterations to our property, because I think Your Honor referenced the airborne nature versus the surface nature, we do know that COVID can be transmitted from a surface. So the surface is in an unsatisfactory state. Because of that, we had to go through all these procedures of cleaning and disinfecting, but it's more than that. It is reconfiguring our spaces. It is installing new walls and doors. I mean, there's all these property reconfigurations. But I think what I want to be really precise about, Judge Elrod, what you're talking about is sort of the second step of the analysis. If we have shown physical loss or damage, how does that physical loss or damage cause the losses that we are seeking in this lawsuit? We have pled that, but they didn't challenge it in their motion to dismiss. If you go back and look at the motion to dismiss raised two grounds. One, that there is no physical loss or damage. Again, to Judge Duncan's point, they sort of cited the existing authority.
That was a good way to go, don't you think, if we got cases that say that?
I understand that, Judge Elrod, and I probably would have done the same thing on their side, but our allegations are different and our policy is different. And because of that,
You say that your policy is different. Point me to the specific language in your policy that is materially different from any of these other cases.
Yes, Your Honor. It is the overlapping periods of liability language, it is on ROA 285, and that's the overlapping periods of liability language. And when we're talking about this language, we are in the communicable disease coverage, and that's the unique coverage that Baylor negotiated and purchased. Not every policy has this communicable disease coverage. Now, standing alone, what
Money paid under that clause, communicable disease coverage?
Say that again, Your Honor.
Money paid out.
Money was paid, and we are not disputing now the payment of that money under the communicable disease coverage as it stands alone.
Look, so there's a different clause for communicable disease coverage, and money gets paid out under that clause. And you think that fact helps your case?
Yes, Your Honor, because in the overlapping periods of liability language, what it says is there's a provision that says if we've got the period of liability triggered under the communicable disease coverage, that period of liability is part of and not in addition to the period of liability for the general time element coverage. And that's the coverage that requires physical loss or damage. So when we've got this provision that says, okay, it contemplates there's this scenario where we do have overlapping periods of liability, both under the communicable disease provision and under the general time element coverage, that can only be triggered if a communicable disease has triggered both periods. And the only way that could happen is if a communicable disease causes physical loss or damage. So their argument in the brief, Factory Mutual's argument in the brief is to say, you can't read it that way. This goes a bit to your point, Judge Duncan, because if you read it that way, that means the communicable disease coverage is meaningless. We didn't need it because we already had it covered under physical loss or damage, but that's just not true. We pointed this out in our brief, that the communicable disease coverage exists for those communicable diseases that do not cause physical loss or damage. There is a distinction in this communicable disease world.
Tell me a communicable disease that doesn't cause physical loss or damage.
HIV is the one that we pointed out in our briefing.
Until the science shows us different, right? Maybe HIV bonds to counters.
I suppose under the logic of my argument, yes, Your Honor, if a scientific study, well, I mean, look, ultimately, what we have to do is we have to, based on the allegations that we have, make the best
Based on
arguments.
this new science, what are people now doing with respect to COVID? that it bonds to services? Are people doing something different now?
No, I think ultimately the repair measures look a lot alike.
Are they tearing out walls and tearing up counters and tearing out ceilings?
Not to my knowledge, Your Honor. But ultimately, I think that question about what was the extent of the repair and the remediation that we undertook, that again is a second level question under the period of liability. That goes to how much were our damages, right? The period of liability says if you've got physical loss of damage, your period of liability under the time element provisions will go until the buildings and equipment can be repaired or replaced, made ready for operations under the same or equivalent physical or operating conditions. So again, that's a whole analysis that we'd have to tick through were we able to get past the motion to dismiss phase.
Can we go back to the language physical damage that Judge Duncan was talking about with you earlier? Our case law says that we must interpret the words physical damage the same way in insurance policies so long as the term isn't defined.
That's right.
And it isn't defined here. So we have to interpret physical damage the same way that we interpreted it in all the other cases.
And I'll amend my statement. So what Texas law says is when we've got an undefined term, we give that term its ordinary meaning unless the policy indicates that the parties intended to mean that term in a different way.
Right, which is why we said, is the term defined, or does it have some other, are you saying the term means something different here?
I am, Your
Do
Honor.
you have some proof of that? Because it's not defined to mean something different.
And that's the overlapping periods of liability language. I think if you look at the RSUI versus Lind case, when you read a provision in the overall context of the policy, I think, with respect, Judge Elrod, I don't think the only way you can give the language a different intent is by explicitly defining it that way. I think what Texas law says is if the context of the policy says, in order for these provisions to all work together, we have to give the term a different meaning. I think that's what Texas law says you do.
What do we do with the new case from the Houston court?
Yes, Your Honor. Appreciate the opportunity to respond to the 28J letter. It has no bearing on this case because, again, this communicable disease coverage that I'm talking about here, there was no communicable disease provision in that case. In the Baylor,
no overlapping policy?
not to my knowledge. There's no and it's really the definition of communicable disease is more relevant for purposes of this argument than the overlapping periods of liability because what the contamination exclusion says, and that's what was at issue in that Baylor College of Medicine case, was the contamination exclusion. In our policy, we have a contamination exclusion. It's different. What the definition says is it excludes certain conditions of property, and it lists foreign substance, impurity, pollutants, and then it lists virus, bacteria, or disease-causing agent.
So do you think your policy is just the unicorn of policies, or do you think that we were wrong and also the Houston court was wrong?
I'm not sure. I don't think I'd say the Houston court was wrong because they didn't have the communicable disease coverage. I'm not sure this court's opinions are wrong because they didn't have this coverage to evaluate.
Is your policy a unicorn policy, or are you just making smarter arguments than anyone else who's ever argued before?
I'm not sure I'd say it's a unicorn, but I do think it's unique. I think if you look particularly across the case law, I do not see that many policies that have this communicable disease coverage that Baylor purchased that says we will provide coverage for communicable diseases. And that's where
Methodist didn't purchase communicable disease coverage, but Baylor did? That doesn't make sense to me.
Well, and I don't know that, Your Honor. I don't know that I've seen a Methodist case, but
Oh, I'm sorry, is that not Methodist? Who is it? Is it Baylor also?
that was Baylor College of Medicine.
Baylor College
I'm
of
sorry.
Medicine.
Yes.
So why would Baylor, Scott and White do it, but Baylor College?
I'm
I
just
know
not-
they're different.
I'm-
I understand
yeah.
the corporate structures.
I'm just not familiar enough with those negotiations to know how an insured would think, all right, we're going to be covered under something else, but not purchase this extra communicable disease provision. All I can say, Your Honor, is I have got to evaluate the language that we have in this policy. And the problem with the contamination exclusion is when it says we are excluding virus, bacteria, disease-causing agent. At the same time, the policy says we are covering communicable diseases. And the policy says, if you look under the header for additional coverages, and that's where the communicable disease coverage sits, it says these coverages are subject to the exclusions. And that includes the contamination exclusion. So we've got to read them together, and the way you do that is what we've offered in
Do
our.
you want us to certify this to the Texas Supreme Court?
I think that would be a sensible way to go, Your Honor. I mean, here's my position. I think based on what we've talked about today, I think you can reach a different result based on our more detailed allegations of physical loss or damage.
Without running afoul of the rule of orderliness.
I do think that because this court hasn't seen allegations like this before, particularly when you combine it with the unique policy language that we have. But look, I understand the sort of hill I'm climbing here, and so if you have some hesitation about that, I think certification is a valuable option because these are important terms, both for COVID and for a lot of other areas in property coverage that I think it's important to have the Texas Supreme Court weigh in on.
Thank you. You saved time for rebuttal. Okay, we'll hear from Ms. O'Malley now.
Good morning. May it please the court. Excuse me. My name is Shannon O'Malley, and I represent the Appellee Factory Mutual Insurance Company. The district court's order dismissing this case was proper, and it should be affirmed. The law is settled in this and every other circuit. COVID-19 does not cause physical loss or damage to property.
Even in cases with communicable disease provisions, do any of those cases have communicable disease provisions like this one?
Yes, I mean, across the country
Can you
or
cite us one
here?
that, well, let's start with here.
Okay, Fifth Circuit, sure. Well, I will say the Fifth Circuit has not addressed the factory mutual insurance policy or the affiliated FM insurance policy. Those two have very similar language.
So has the Fifth Circuit addressed one that has the communicable diseases and the overlapping, whatever it's called?
No, not this specifically. There are,
Has the state of Texas Intermediate Court addressed that?
no,
So
but
has another circuit or another district court addressed that?
yes, there are 40 courts across the country who have looked at the factory mutual insurance company policy or the affiliated FM policy. 37 of those 40 have found that this policy does not provide coverage for physical loss or damage. The other 3 have allowed it to go beyond the
Motion to dismiss for the reasons that have been articulated by your colleague?
No, for different reasons. There's been different arguments that have been propounded. This argument about the overlapping period of liability, this is the first time it's ever been raised. I think it's a new argument, a new way of looking at things.
Well, if you could address that, it would be helpful. Sounds like that's the main argument.
Sure. And it's difficult for me to address because I don't quite understand it. They're taking the argument that you have 2 provisions. You have a period of liability in the interruption by communicable disease provision, and then you have the general provision. Well, there is a period of liability in the interruption by communicable disease because it's not triggered by physical loss or damage. It only starts when there's an order of a civil authority or a director of the company to come in and say, we're going to shut down this place because there was a communicable disease here, and we're going to keep it closed until it's cleaned up, or we do reputational management. I mean, that's what's getting lost here, is that the communicable disease coverage is available for costs for cleaning up and for reputational management. It's really a recognition that if somebody with Ebola comes onto your site, people are going to be worried about going there. And so you can shut down, put in people with hazmat suits if needed and clean it up. And so the same thing, that's what happened here with COVID.
That's the kind of coverage.
That's the kind of coverage.
I go to my insurance company and say, look, I'm worried that the city of New Orleans is going to shut down my oyster bar because of some disease, and I'm going to be closed, and they're going to have to bring in people in hazmat suits and clean up everything. I need some coverage for that. That's
Right.
coverage you can negotiate for.
That is a coverage you can
What
negotiate.
do we call that?
It's called the communicable disease.
Okay, communicable disease. That's in this policy.
That's in this policy. It's called, there's one called communicable disease response, and that addresses the costs to clean it up and to reputational management. You can hire.
And it does cover this because it's for viruses and things, right?
Right. Well, it's for communicable
And
diseases.
in fact, some claims were paid out under that.
Exactly, and it was paid out here. And in fact,
In this case, how many millions were paid out under that?
5 million.
5 million.
In this case. And the thing is,
What's the claim here for property damage?
property damage, I don't know. I don't think there's any claim
Well,
for
if they
property.
win, what do they get?
They're asking for lost business income. And so they're asking for $192 million.
192 million.
Right. So, and I don't know if that includes the 5 million or not. But the issue is that that's what the response for communicable disease is. Okay. There's a second communicable disease provision, and that's called the interruption by communicable disease. And that is part of the business interruption. It's the time element. It's an extension of the time element. And it applies when you have an order, either by a civil authority or the officer of the company can come in and say, we're going to shut down and we're going to clean up and do what have you. And so your lost income during that period of shutdown, that's what's covered there. And what is the trigger for that is you have to have the actual, not suspected presence of a communicable disease on the property. And so the period of liability for that time that you're shut down, you don't get it indefinitely. It's the period that it starts when the shutdown is issued, the order is issued, and it continues. It can continue for a year, but it continues basically until it's cleaned up. Now, the other period of liability, which would be the general time element period of liability, that addresses physical loss or damage. And that is for the general, what we would normally understand business interruption to be. And that only starts at the time of physical loss or damage, and it ends when the physical loss or damage could be repaired or replaced. And so there's two different provisions here, and I will say that there is a line in the interruption by communicable disease period of liability that says it's part of and not in addition to any other time element period of liability. But that line doesn't mean that, okay, we recognize that communicable diseases can cause physical loss or damage. It's a huge stretch, and there's nothing in the policy, I think, that where my colleague here argued that the policy is defining physical loss or damage differently because of that part of and not in addition to any other period of liability. The whole point of that part of and not in addition to any other period of liability, it's an anti-stacking language, and it comes up in other areas in the policy. If you look under the limit of liability area, it talks about it's part of and not in addition to. The point is you don't want to say you get that on top of any other limits. It's part of the same limits. They have an overall policy limit.
But does that render some of the policy meaningless, that the opposing, your friend on the other side says that if we read the policy your way, we render some of the language meaningless, and that we're encouraged not to do that in policy interpretation. Can you deal with that?
I don't see how it renders anything meaningless. If anything, their interpretation renders the communicable disease provisions meaningless. And a number of courts, including other circuits, have addressed arguments that have tried to say, well, this policy, FM's policy, recognizes that communicable diseases can cause physical loss or damage. And all the other courts have said that's not right, because why would you have coverage for communicable disease as an extension or as an additional coverage? Why would you have these if the policy already provided coverage for communicable diseases that cause physical loss or damage? And
communicable disease, or otherwise you'd get poured out in the Fifth Circuit for sure, wouldn't you?
Yeah, that's true. But the other issue is that Mr. Guthrie said, well, this policy only applies those communicable disease coverages to certain communicable diseases that don't cause physical loss or damage, like HIV. It doesn't say that in the policy. He's adding words. They're trying to narrow that coverage as opposed to looking at the plain language of the words. And the plain language of communicable disease is defined as, let me say it absolutely specifically. It is defined as a disease which is transmissible from human to human by direct or indirect contact with an affected individual or the individual's discharges. It doesn't say HIV. It doesn't limit it to certain communicable diseases that may not be transmissible or via air droplets, things like that. This is exactly what FM was intending here, was that if somebody comes in with a communicable disease like COVID, and it causes any kind of loss, like, for example, a business shutdown, that if there's evidence that the communicable disease is actually present on the property, the coverage can be provided for that. And they provided that coverage, but the problem for Baylor is that that coverage was limited to $5 million. And I'll tell you that the $5 million is more than most other FM policies. Most FM policies provided coverage for $1 million, and the affiliated FM policies for $100,000. But likely because this was a hospital, and they recognized that there was more of a risk because it's a hospital, they increased that limit to $5 million, and they've paid that. So that language doesn't do anything to change what is physical loss or damage. And this policy has the same threshold requirement that the other 13 cases before this court has had, which is that you have to show there's physical loss or damage to property.
Okay, can we talk about the science? That's how we opened, about that the actual surfaces have had a change, a metamorphosis, so they've become different than they were because of and the science proves this out, allegedly.
Sure. One of the things that Mr. Guthrie said is, well, we know so much more about COVID now than we did. Well, this complaint was initially filed in February of 2022.
Well, regardless of when we know it.
Sure.
Did it change? Don't we have to take that as fact for this analysis at the 12B, and that summary judgment, you could argue that it hasn't really changed at all. But right now, we have to accept that it changed the physical surfaces? Well,
you would have to accept that it changed the physical surfaces if it's a plausible allegation.
And it's got a lot of studies and things, and so it would be hard to find it's not plausible that it changed the physical surfaces.
Sure, but this is not, that what they've alleged, first of all, is not, they haven't alleged that it's caused physical loss or damage here. And he has said, well, we came in, first of all, they said that surfaces have been shown to be rougher. They didn't say that Baylor's surfaces are rougher. They talk about a scientific article where you dipped something in and it showed that the portion that was tested on may be more hydrophobic. They didn't say that Baylor's property was actually hydrophobic. We're also...
The allegation in the case is because the surfaces are all more hydrophobic, we have to rip them all out and replace them, and it's going to cost us $100 million.
That is not their allegation. That is not. And that's the problem, is that they have not been able to connect the dots between this hydrophobia, or the surface roughness, and their loss.
Frank with you, I can imagine some communicable disease that just, it's kind of a horror movie scenario that that sort of manifests itself in the walls. It's in the walls. And, we all heard about this hospital or this house that and nobody goes near it because it's in the walls. And so the only way to remedy it is to, rip it out to the studs and have new walls.
Right. I mean,
I can imagine that.
I mean, there's black mold, but that's not a communicable disease.
Mold could cause diseases. Mold could also destroy the property.
Right. I mean, and I've brainstormed this. I'm thinking, what kind of communicable diseases could possibly? Because I don't want to foreclose that it potentially is something out there, but we haven't seen it yet. If I have COVID right now and I sneezed, you're not going to throw this away. You're not going to throw the podium away. You can wipe it down. You can take a Clorox wipe and wipe it down. And so that's the thing. And when they talk about surface roughness, they're talking about the topography of the surface, right? The surface isn't changing. If I put my pen on this here, I've changed this. This is now rougher, is what we're talking about. That's all that is. And so, yes, they haven't connected the dots. And they've said that we didn't discuss this in our briefing. We did discuss it. I can point you to the place in the record at 394 in our initial briefing. And it was very much discussed in our oral argument before Judge Jordan, who asked, if you look at that, he asked again and again, how is this allegation of physical loss or damage causing what you are claiming here? How did it cause your lost income? And the only thing they could point to were the mitigation things that they did to protect people. And that's when you coming back to what the Fifth Circuit has looked at before. You guys have already considered this in terms of what needs to be done to demonstrate physical loss or damage. You have to demonstrate that property needs some kind of repair, that it's damaged in some way that's lasting. And COVID-19 isn't lasting.
What do we do with you're arguing that you can wipe it off with these wipes, but in their pleading at paragraphs 82 through 85 or so, they're talking that it said included real and personal property at the facilities, that it caused a tangible alteration on that property. So it said it did actually happen on this property, and that there was no effective way to remediate that. And then it says in the paragraph 84, cleaning and disinfecting did not repair or mediate. So they're refuting exactly what you just said in their complaint. And if we're at 12B, I don't think we can take into consideration your common sense, just clean it off with a bleach wipe or something.
Sure. Well, first of all, them saying that COVID-19 tangibly altered my property, that's a conclusory allegation.
Well,
they haven't shown how.
They've got science, and then they say it happened here. And so I don't know that that's not an adequate pleading of that. I'm not judging it right now.
Sure. No, but it is a conclusory allegation, and the thing is, you have to say, give you more information than that.
Do you object that this was a conclusory allegation, and that's the basis of your challenge to the 12B?
We absolutely said, but conclusory allegation means it's not plausible, and we did argue that in our 12B motion to dismiss, and it is discussed in Judge George's order.
No, actually, they're two different things. It is plausible because there are scientists who say this does happen in places. So it's not a moon is made of green cheese, and it does have some meat on the bones.
I disagree that it has meat on the bones, because they just say, okay, it's changed. But where's the damage? They're focusing on what's physical, right? Which is tangible alteration, but it has to be physical loss or damage. So where's the harm? Where's the damage? Where's the injury to the property that requires repair? Now, they did say,
why is that damage, property damage?
right, and it's not property damage. And the issue is, one of their allegations is it can't be just disinfected because you have a new person with COVID walking around sneezing and reinfecting. Their argument is basically that they are in a constant state of damage, and they're going to be perpetually in a constant state of damage with no beginning and no end. And that's not what insurance provides coverage for. You have to have a discrete event of physical loss or damage, and it has to have a beginning, when is the damage, and then an end, when can it be cleaned and brought back to how it was before.
Can it ever be in these circumstances where we have all these things floating around in our environment? Does it work?
They don't cause physical loss or damage. That's the point, is that these things floating around in the environment, if I sneeze now, it is going to land on here, and any kind of bacteria that might be in my mouth, whatever, it's going to land on here, and it's going to sit there.
I'm sorry, I just did sneeze in this argument, so.
Well, I didn't hear you, so bless you. But the point is that they have not alleged, they haven't properly alleged the physical loss or damage to the property.
What do you think about certification?
I don't think it needs to be certified.
Would you like to know this? Do you have any other Texas policies?
Do I have other cases?
You have this policy in Texas. Is this policy language anywhere else in Texas, or is this a one-off unicorn?
This is not a one-off unicorn. There is one other case that is up in its front of this court that's pending and written. It's the Cinemark case. As far as I'm aware, there's no other COVID-related cases, but there are other factory mutual policies out in Texas. But it doesn't need to go before the Texas Supreme Court. If it needed to, it would have gone back when this court decided Terry Black's. And the court decided at that time there was sufficient information from the Texas Supreme Court with U.S. Metals and other Texas appellate courts to give this court the information it needed to understand what the meaning of direct physical loss or damage is. And so sending this case now to the Texas Supreme Court after it's already heard and decided on 4 cases under Texas law.
Well, it keeps coming up, so maybe we do that. Sometimes it takes us a while in insurance especially, that we have a whole bunch of cases and then we finally send it and then we find out, and I'm not saying this would happen here, you might very well be vindicated, but that we sometimes find out we've been doing insurance law for 5 or 10 years wrong. And Texas corrects us.
Sure. I just don't think that this is the one that needs to go up there. I don't see, given the overwhelming way that courts have been looking at this.
I know you're running out of time, but I'm just trying to look in this policy and see if there's anywhere where contamination interacts with physical damage, since that seems to be the gist of this. Sure. I'm looking at a part in exclusions. This is on 242 of the record. It's part D under exclusions. It says this policy excludes the following unless directly resulting from other physical damage not excluded by this policy. And then 1 is contamination, any costs due to contamination, due to the inability to use or occupy property, any cost of making property safe and suitable. If contamination due only to the actual non-suspected presence of contaminants directly results from other physical damage not excluded by this policy, then only physical damage caused by such contamination may be insured. So that's the only place I've been able to find where you've got the idea of contamination, the idea of physical damage sort of interacting. What do you say? Does that help or hurt your argument? Is that relevant at all?
So I'm out of time, but may
Please,
I answer?
go
Okay.
ahead.
No, this is actually very helpful, and it's another reason why it doesn't need to be certified to the Texas Supreme Court, which is because the policy does have a very expansive contamination exclusion, and contamination is defined to include a virus. And so to the extent that any condition of property is affected by a virus, it's excluded under the policy, except to the extent that there's coverage under the communicable diseases. And if you look to page 235 of the record, that is where exclusions are identified, and it states that in addition to the exclusions elsewhere in this policy, the following exclusions apply unless otherwise stated. So the policy's general, you first have to have physical loss or damage unless excluded, so that it doesn't meet the physical loss or damage. Then it's excluded because it is considered contamination unless otherwise stated. And it is very, there's a carve out of coverage, essentially an exception to this exclusion for communicable diseases when they have some kind of effect on the property or on the business. And courts have accepted that.
Quick question, the opposing counsel says your documents confirm that COVID-19 could cause this physical loss or damage. Is that true? You're not refuting that in a particular case that could happen, but you just think it didn't get proven up enough for 12B in this case?
No, I think that he's relying on extrinsic evidence to create an ambiguity. There are some documents out there that plaintiffs have said make that statement. But no, I think that
That statement.
I'm sorry?
Do they make that?
They don't make that
Their
statement.
own
But
documents, do they make that statement?
no, instead, I think that there's I said this before, I have racked my brain to try to come up with, is there a way that communicable disease can cause physical loss or damage? There might be. I can't foreclose that, but COVID-19 does not cause physical loss or damage, and it has been
Not
determined.
find that in your documents.
It's not. You wouldn't find that in the
Okay,
documents.
just, that was in the brief, so.
Yeah, but it should not be considered in interpreting the policy because it is extrinsic evidence, which should not be considered in determining whether or not there's an ambiguity under Texas law. All right, thank you very much for your time.
Thank you, Your Honors. I'll start near the end and sort of go backwards to Judge Duncan's question about the contamination exclusion. Look, the only reason there would be an exclusion in the policy is if it falls under the general ambit of coverage, right? So the contamination exclusion talks about conditions of property And again, we have an exclusion for these conditions of property that would otherwise fall within the physical loss or damage. That's why they have exclusions. In this case, though, the way the contamination exclusion is drafted, when you have to harmonize it with the communicable disease provisions, it has to be read narrowly, such that the terms viruses, bacteria, disease-causing agents are read to exclude communicable diseases. And that brings me to another point that I want to make. Judge Elrod had some questions about what are the Texas courts doing. We talked about the Baylor College of Medicine case. We talked about how there is one appellate opinion that addressed whether the contamination exclusion applied under one of the policies at issue in the Baylor College of Medicine case. Well, there are other insurance policies, and they went to trial on those insurance policies because they have different contamination exclusions. The Texas State Court found that there was a fact issue on whether COVID caused physical loss or damage under the meaning of the property insurance policy there, denied summary judgment for a set of the insurers, sent the case to trial. They had a jury trial. They heard this evidence about physical alteration, what happens to the property. Say again?
What court?
It was one of the district courts in Houston. So I know the courts that the appeals are pending in, or the 14th District Court of Appeals in Houston. It's a Harris County trial court. And the jury ultimately found COVID did cause physical loss or damage at Baylor College of Medicine. There was a $12 million judgment. That judgment is currently up on appeal, but we don't have an answer yet, right? And so when we're thinking about what does Texas law tell us, there's one appellate case that says something about some contamination exclusion, not ours. Doesn't say anything about the communicable disease coverage, but we have this jury verdict, and we have several trial courts saying there's a fact issue. So in our view, I think at a minimum, Texas law is in flux on this issue.
Well, the fact issue implies to me that you've made some kind of allegation, and we have to test whether it's true or not. So I understand what you're saying about physical. You're saying there's some new science that shows COVID bonds to surfaces and changes their nature.
That's right.
What have you alleged about the damage that causes?
So when I look at what the current eerie guesses are,
I'm just asking, what do you allege as the damage that causes?
well, the damage is an alteration. The term.
Where is that in the policy? Damage means alteration?
No, this court has construed physical damage to mean a tangible alteration or
How does
deprivation.
that hurt your client? Assuming this is true, that there's the spike proteins bonding,
Right.
How does that hurt your client?
It hurts our client because in remediating that physical alteration of our property, there were all of these, and we listed these out in the complaint, administrative and facility measures we had to take to do all this cleaning and disinfecting. There were
Cleaning? You have to clean a lot.
cleaning is part of it. There were temporary walls, temporary doors, I believed, installed. Rooms had to be closed off, turned into clean rooms, rather than, right? So this is a hospital. We have to make sure we can still continue to treat patients. But through all of those measures, Judge Duncan, what we've alleged in our complaint.
When there's a separate coverage under communicable disease response that covers cleanup, removal, and disposal of the actual not suspected presence of communicable diseases, why isn't the policy talking about exactly there what you just talked about, which is in a different part of the policy that does not require physical damage?
And I haven't gotten all the way there, and that's my fault. We are not seeking to recover the expenses for those measures, but what those measures caused is it limited the patients that we could treat and the procedures that we could perform, and that limited our income. We are
Common sense that if you're claiming recovery for physical loss or damage, it's to replace what was physically lost or damaged. Not, well, it changed my business and I couldn't see as many patients.
Except that this policy under the time element coverage says that we will pay you for your business interruption that results from the physical loss or damage. And that's what we are seeking, is the business interruption that results from the physical loss or damage. And so ultimately, Your Honor, I said this before, that's what has to be tested through the fact process. It wasn't challenged on the motion to dismiss, and so we'd ask you to reverse and remand. Unless Your Honors have any further questions.
No, thank you.
Thank you much.